Welcome to the debate. Today, we are diving into a pretty intense procedural battle. It really cuts to the heart of what constitutes medical fraud in New York civil litigation.
That's right. We're looking at a motion to dismiss counterclaims. These were brought by what we're calling the Sholom Parties, think the insurance side of things, against a physician, Dr. Alexios Apazidis.
And this isn't just, a standard malpractice dispute. The counterclaims allege intentional fraud, systematic deceptive practices under General Business Law Section 349. And the allegations themselves are, frankly, startling. Unnecessary surgeries, and this really shocking claim of using copy-pasted operative reports across many different patients. A very tough standard.
Indeed.
Now, I'm taking the position that the Sholom Parties have stated viable claims here. I think they've met the required particularity, and frankly, I believe the motion filed by Dr. Apazidis is procedurally flawed right out of the gate.
And I'm arguing the opposite. Despite how serious these allegations sound, I maintain the Sholom Parties just don't have the legal standing to bring these specific claims. Their pleading, as I see it, is built too much on speculation and simply fails that critical test of particularity under CPLR 3016B. Okay.
The doctor's legal team, they failed to include and argue against roughly 2/3 of the relevant pleading. They completely ignored the fully incorporated 33-page related counterclaim Exhibit 3, which was explicitly referenced and made part of the pleading. Now, this isn't some minor slip-up. This violates core procedural rules like CPLR 3014, which mandates addressing the entire pleading. Then what's more, by submitting extraneous material documents outside the actual complaint, the doctor actually increased his own burden. Under cases like Stewart v. Feinsuch, he now has to show that a material fact claimed by the Sholom Parties is not a fact at all and no significant dispute exists. He didn't even try to meet that higher burden. So procedurally, I think the motion is just untenable from the start. But even setting that aside, substantively, the claims are strong enough to proceed. The fraud claim, I argue, survives under the doctrine of indirect reliance, the so-called Eaton doctrine, which Pasternak confirmed is still viable. The core allegation is that these false operative reports, they were created by Dr. Apazidis intending that they be passed on to and relied upon by the insurers, the Sholom Parties, forcing them to defend the resulting lawsuits. In the GBL 349 claim, the consumer protection claim, that's also viable, because the alleged scale identifying, I think the latest number is 42 and counting, identical cervical operative reports used for different patients, that sheer volume points towards a systemic issue with the kind of broad public impact that the law requires, as seen in Carlin v. IVFM.
Okay, I see the procedural point, though I think the court might overlook it to get to the merits. But let's focus on the law of fraud, because I think that's where the Sholom Parties case really falls apart. You can allege terrible things, but if the legal framework isn't there, the claim just doesn't stand up. The counterclaims, when you strip away the rhetoric, are conclusory. They paint a very dark picture, yes, but they lack the specific factual details required by CPLR 3016B. The biggest hurdle, as I see it, is standing. For a fraud claim in New York, generally, you need direct reliance. The person defrauded needs to be the one who directly received and relied on the lie. Dr. Apazidis made no direct misrepresentations to the Sholom Parties.
But the intent...
Well, let me finish. The Court of Appeals in Pasternak, even while discussing those nuances you mentioned about Eaton, was quite clear. Reliance generally can't be based on a third party like the patient or their lawyer relying on a false statement, which then causes harm down the line to the insurer. That chain is usually too weak for fraud. And they lack standing for the GBL 349 claim too. That law is meant to protect the public marketplace from deceptive practices aimed at consumers. The Sholom Parties' injury here is, well, financial loss from defending a lawsuit. It feels very indirect, quite remote, similar, I think, to the kind of attenuated injury rejected in Blue Cross v. Philip Morris. Treating two specific patients, Levy and Davey, even if done badly or fraudulently, doesn't automatically become consumer-oriented conduct affecting the public at large.
And finally, this core idea that using a template report proves the surgeries were knowingly unnecessary. Well, that's a leap. It's conjecture about the doctor's mental state, his scienter, which is a crucial element of fraud that needs specific factual backing.
Okay, let's zero in on that standing issue for fraud, because you're right, that's a critical legal point.
You're arguing the claim fails because there was no direct lie to the Sholom Parties. You cite the principle that fraud is personal to the defrauded party. Fair enough. And you characterize the Sholom Parties' claim as being based on this indirect chain. Doctor lies to patient relies, lawsuit happens, insurer gets harmed defending it. You say that's too attenuated, citing Pasternak.
Exactly. It stretches the concept of reliance too thin for a traditional fraud claim.
I understand that reading, but I think it's, well, perhaps too narrow a reading of what Pasternak actually allows, especially concerning the Eaton doctrine. The Court of Appeals didn't shut the door entirely on indirect reliance. It specifically kept the Eaton pathway open.
But with strict limits.
With limits, yes, but the key limit isn't just if the doctor lied, but whether the lie was specifically aimed at the eventual plaintiff, even if communicated indirectly. The Eaton doctrine, as affirmed, says a fraud claim can be viable if the false statement was made with the specific intent that it be communicated to the plaintiff here, the Sholom Parties, and that the plaintiff rely on it. Think about it like this. It's the classic example. If I lie to a car appraiser about a car's condition, knowing full well that the appraiser will use that false information in a report that you will then rely on to buy the car, I didn't lie directly to you, but I absolutely intended for my lie to reach you and deceive you for my benefit. That's the essence of the argument here.
The pleading alleges these reports weren't just for the patient file. They were allegedly generated specifically to justify insurance billing and to withstand scrutiny and litigation, intended to deceive the payer, the insurer. That specific intent, if proven, elevates it beyond simple third-party reliance.
Okay, but that intent, isn't that the giant question mark hanging over this whole pleading? How can the Sholom Parties at this stage, before any discovery, possibly know for sure what the doctor's specific intent was? How do they distinguish between an intent to defraud the patient, which might just be malpractice, however egregious, versus a specific, separate intent to defraud the insurer? Isn't that exactly the kind of speculation that CPLR 3016B is designed to prevent?
But the pleading provides the basis for inferring that intent.
Does it? Because, I'm sorry, I just don't accept that using an electronic medical record, an EMR template, somehow automatically translates to proof of fraudulent intent, the necessary scienter. CPLR 3016B is notoriously strict in New York. You have to lay out the circumstances of the fraud with detail, the who, what, when, where, and crucially the why, the intent. It's much tougher than basic notice pleading. The whole case seems to hang on these copy-pasted reports. But the mere existence of a template, even one that's used repeatedly, maybe even carelessly, across multiple patients, that doesn't inherently prove the doctor knew the surgeries were unnecessary at the time he did them, and that he created the report specifically to mislead the insurer. Those feel like conclusory leaps about his state of mind, exactly the kind of thing courts often dismiss at the pleading stage.
I have to disagree strongly there. I don't think it's mere templating or speculation. The pleading is actually quite particularized about the scheme itself. It clearly identifies the alleged misrepresentation. The operative reports it claims are false because they don't reflect unique patient procedures, and it explicitly identifies the motive, the scienter. Dr. Apazidis allegedly did this to protect his lucrative referral stream and assure continued payment, essentially for monetary gain. The core allegation isn't just a template. It's that he used a verbatim, identical operative report, word for word, in, at last count, 42 distinct cases for different cervical spine surgeries on different people. That sheer volume, that alleged pattern, it moves beyond just potential malpractice or sloppy record-keeping. It suggests something more like a medical assembly line, frankly. That scale, explicitly linked in the pleading to a financial motive, provides a sufficient basis at this stage to draw a reasonable inference of intentional, systematic fraud. Remember, we don't have to prove the entire case right now. We just need to state a cause of action that's plausible and sufficiently detailed under 3016B. I firmly believe this pleading does that.
Okay, all right. Let's even assume, just for the sake of argument, that you somehow get past the specificity hurdle on fraud, which, again, I strongly contest. You still slam right to the wall of damages. What damages are actually alleged here? Vague, unspecified legal fees and investigation costs. We have the American rule in this country. It's fundamental. Each side pays its own legal fees unless there's a contract or specific statute saying otherwise. Trying to claim these litigation defense costs as the direct damages resulting from the alleged fraud, that feels incredibly remote, very attenuated. The Sholom Parties are insurance entities. Investigating and defending claims, even potentially fraudulent ones, is part of their business. It's not the direct, out-of-pocket loss typically required for a fraud claim itself.
That's a standard argument, and the American rule is certainly real, but I think you're overlooking key case law, where the fraud itself is what causes the litigation. When the entire point of the alleged fraud is to manufacture a basis for a claim or a lawsuit, forcing the plaintiff to incur costs to defend against it or uncover the truth, then those litigation costs can be considered direct damages.
That's a narrow exception, though.
It is, but it applies here, arguably. And look, the courts are actually split on this. I'd point to recent cases, the Second Department just last year in Jimenez versus Pepsi Cola, and the First Department back in 2019 in Artemis USA v. Paul Kasman Gallery. They both found that litigation costs spent defending a lawsuit that stemmed directly from a defendant's misrepresentation are potentially viable damages. They're enough to keep a fraud claim alive past a motion to dismiss, like this one. If the allegation is that the doctor's whole fraudulent scheme was aimed at triggering lawsuits to get paid, then the cost of fighting that manufactured suit isn't remote at all. It's arguably the most direct injury possible. The fact that the appellate divisions don't see eye to eye on this specific point actually strengthens the argument to deny dismissal now and let the issue be developed.
Okay, an interesting point on the damages split. But let's quickly turn to the GBL 349 claim, the consumer protection one, because I think that fails regardless of the damages issue for fraud. You're hanging your hat on the volume, the 42 and counting reports, to argue there's a broad public impact. But GBL 349 requires the conduct itself to be consumer-oriented. It's not just about being harmful or even systematic.
Right.
A doctor's treatment of individual patients, even if it's repeated across many patients, isn't typically considered consumer-oriented in the way the statute intends. That usually involves things aimed at the public market, like deceptive advertising, misleading packaging, things consumers encounter directly. Here, we're talking about alleged deception within the private, highly specialized context of medical treatment for two specific individuals, Levy and Davey, and the subsequent fallout in a personal injury lawsuit context. The Sholom Parties, as insurers, are basically claiming an indirect financial injury from having to fulfill their defense obligations. That feels too remote from the consumer marketplace to meet the standing requirements for GBL 349. It looks like an attempt to shoehorn a medical dispute into a consumer protection framework where it doesn't really fit.
I see it differently. I think the sheer alleged scale does transform it. When you have potentially 42 identical reports for complex, unique cervical spine surgeries, that signals a systematic practice that does have a broad public impact precisely because it allegedly targeted the insurance system. This isn't just about Levy and Davey's individual care, it's about a pattern of behavior that, if true, deceives the entities paying for health care across the board. When insurance fraud occurs on that scale, who pays? Ultimately, all consumers do, through higher premiums and potentially reduced access to care. That feels exactly like the kind of widespread conduct harming the public indirectly that the Court of Appeals in Carlin v. IVF AMS at GBL 349 is designed to address, even if the initial interaction wasn't a typical consumer transaction like buying a toaster. The alleged deception has a broad ripple effect impacting the healthcare market, which affects consumers at large.
So wrapping up my view, look, the allegations about these copy-pasted reports are certainly serious, potentially disturbing. But from a purely legal standpoint, the counterclaims just don't hold up right now. The Sholom Parties haven't adequately pled direct reliance for the fraud claim, and their allegations about the doctor's intent, his scienter, lack the specific factual detail demanded by CPLR 3016B. The GBL 349 claim also fails, in my opinion, because the conduct isn't truly consumer-oriented in the statutory sense, and the alleged injury is too indirect. As pled, these claims are legally insufficient, and they should be dismissed.
And I'll reaffirm my position. The counterclaims have stated valid causes of action that deserve to proceed. Procedurally, the motion against them is flawed from the start for ignoring a huge chunk of the actual pleading. Substantively, the claims are well grounded in New York precedent that, 1, allows for indirect reliance when specific fraudulent intent directed at the plaintiff is alleged, Eaton Doctrine via Pasternak. And 2, recognizes that litigation costs forced by a manufactured suit can be direct damages, especially given the split in appellate authority. This case really highlights the tension in applying these strict pleading rules to complex, potentially systemic medical fraud. But at this early stage, before discovery, the Sholom parties have alleged enough specifics, enough of a pattern, to state cognizable claims that should survive this motion.
It certainly highlights that tension, the difficulty of pleading fraud with such particularity, especially regarding intent, before you've had discovery. That remains a central challenge for plaintiffs and the courts in these kinds of cases.
Absolutely. And clearly, regardless of how this specific motion turns out, there's much more to understand here once, or if, discovery proceeds and the full facts surrounding the scale and nature of this alleged operative report issue come to light.